Are you aware of your employee rights in the UK? Have you recently had a disagreement or a difficulty with your employer and you want to know where you stand? Or are you in a position where your job is at risk and you feel you're unsure of what rights you would have as an employee in the UK? Well, that's a question I'm getting asked quite a lot at the moment, so it makes sense to do a video on it. So in this video, what I'm going to do is go through the basic key employment rights that every employee in the UK should be aware of. Now, if you haven't seen our channel before, we do videos aimed to help employees. And that's employees either in employment or those seeking employment. The purpose of the channel is to be very authentic, very real and bluntly honest at times. We don't want to hold back, we want to give you an actual scope of what's really going on out there. If you like this kind of stuff, do consider subscribing to the channel, and at the end of this video, if you do like it, give us a thumbs up. So what are your basic employment rights in the UK? Well, in this video, I'm going to go through all of the key employment rights that you should be aware of. The first one I want to go through is one that catches a lot of people out. Until you have worked for a company for 2 years, then you're in a position where you don't have your full employment rights. What a lot of people don't realise is that within the first 2 years, you're not only not entitled to things like redundancy pay if you are let go, the company can actually let you go for whatever reason they want at any point. As long as it's not discriminatory or they fired you because you have information about them conducting some illegal activity, for example, then if they just don't like you, if they just don't think you're a good fit, they don't like you standing on the wrong bit of tile in the office, they can fire you basically for whatever reason they want. And to be honest with you, there's not really much you can do about it. A lot of people aren't really aware of that. A lot of people also think that because you have a probationary period, say 3, 6 months or even a year, once you've completed that period, and even if HR have signed off to say you've completed your probationary, well, that's it, you're safe, you have rights. But that's not actually the case. You see, any point during the first 2 years, regardless of whether you've completed your probationary period or not, if the company want to get rid of you for whatever reason they like, they can. Have you ever heard the term last in, first out? Well, that's pretty much what this comes down to. The next employment right I want to go through is about lunch breaks. Now, lunch breaks are actually a pretty common question that I get. A lot of people will come to me and ask, well, how long am I allowed to have a lunch break for? Is my employer allowed to restrict me? Are they doing the right thing? What are my rights? Now, officially in the UK, for every 4 hours you work, you're meant to have the 5th hour as a lunch hour. So if you work 8 hours a day, you can have a 1 hour lunch break smack bang in the middle, because you'll do your first 4 hours, have a lunch break, do 4 more hours, and then you're going home anyway. So they're perfectly entitled to do that. And a company is also allowed to break up that lunch hour into 2 or even 4, if they wanted, separate quarters of that or halves of that. So if they wanted to do a half hour here and a half hour there, or even 4 15-minute breaks, they can do that, as long as every 4 hours worked, you are given an hour for break. That's what they have to do under UK employment law. Now, one question I also get with that is that, will my employer put in the contract that I only have a 45-minute break? That surely means because I've signed up for that, then I have to have only a 45-minute break. Well, that's not really going to stand up in a court of law. It doesn't matter what it says in your contract, and if I'm being honest with you, and I could do a whole separate video on this, there are many things that are written into employment contracts that as soon as you walked into a court of law, they would laugh you out of the court, or laugh your employer out of the court, and one of them is lunch breaks. Under standard UK employment law, you have a 1 hour lunch break for every 4 hours worked. Yes, as I say, they can break that up, but a company cannot write it into your contract and then enforce it that you only have a 45-minute break. You are fully entitled to your 1 hour lunch break. The next employment right I want to go through is about holiday allowance. You see, with holiday allowance, it can differ depending on how many days per week you do across the year on your actual employment contract. Now, this can be slightly different if you're a contract or a temporary worker, and to be honest with you, that comes under a whole different degree. So to cover myself, the employment rights I'm going through here and in this whole video, to be honest with you, are actually going to be about permanent contracts. Now, this could be either you're on a full-time hours, say doing 40 hours a week, or even 25 hours, but with this, I'm going to give you the relevant equivalent. So listen carefully to this part, because I don't really want to confuse you too much. The way they calculate holiday entitlement in the UK is based on days worked per week, not hours worked per week. So if you work 5 days per week, let's say Monday to Friday, you're entitled to 20 days as a minimum statutory holiday allowance plus 8 UK bank holidays. Now those UK bank holidays can differ depending if you're in Scotland, for example, or Wales or England. They can change around. But you are actually entitled in any of the UK countries to 20 days as a minimum if you work 5 days a week for a whole year, and then you have the 8 days bank holiday on top. Now the 20 days you can pick and choose when you want them, and a company is also allowed to appropriate some of those hours to your Christmas holiday allowance. So they can say, certainly if the company's closing down during Christmas, look, we have to appropriate 4 days, for example, for your Christmas allowance, that's it, and they'll put that into your contract. And if you sign to say you agree to that, then it is seen as reasonable in a contract of law. So they may give you the 20 days, but they may proportion some of them for Christmas, for a shutdown period, if they're a company that might shut down in August, for example, and they are legally entitled to do that. So even though you're given the 20 days holiday as a standard statutory, it doesn't mean that all of those 20 days you can then pick and choose when you want to do it. A company as well can also put in the contract that there'll be certain days of the year you cannot book holiday, or there'll be certain periods of the year, certainly dependent on the type of trade that the company does, that you can or cannot book holiday on. Now they have to be fairly careful to still give quite a lot of flexibility, but they are allowed, for example, if it's Christmas and they're a retailer and it's December, they can by all rights say, look, as a company policy, if you sign up on our contract, as a company policy, we don't allow anyone to book holiday during December. And that will stand up because it's seen as reasonable. It would be detrimental to their business. You're signing a contract, they're making you aware of it. That seems okay, and therefore it would be upheld in a court of law. Again, if you're a tourism company and your high season's August and they say, right, you cannot have anything during August because kids will be off school, again, they are well within their rights to say you cannot book holiday during that period. But for the majority of the year, if you're given those 20 days statutory, then you can book them when you want. The 8 days bank holiday, they are fixed. There are obviously bank holidays on there. But again, some companies can say with bank holidays that you need to work those days. It might be the sort of job where they need someone on call, or their business is not closed down on a bank holiday, they need people to work, in which case if you do have to work on a bank holiday, you're entitled to a lieu day off. A lieu day being a day that you can use as and when you want with appropriate notice. Now bear in mind with those 5 days, as I say, if you are on part-time hours, then this will go down by 4 days per day. So if you're working 5 days per week, count each of those days as 4 days. 4 days per week, instead of you having 20 days off, 20 days as a statutory allowance over a year as you would on 5 days, you only have 16 days off. Hopefully that at least explains to you what your allowance is as a holiday allowance. Earlier in the video, I said about the first 2 years of employment where you wouldn't have full employee rights. But what about after 2 years of employment? Let's say a company wants to get rid of you then. What do? What are your rights at that point? Well, there are 2 ways basically of getting rid of you from a company. There are either finding a reason to dismiss you from the business, and that could go through a format of an investigatory and then a disciplinary process, and then finding you guilty of some form of misconduct, or the other form of it is through a redundancy period. Now, a redundancy period, I don't want to go into too much detail about that because we did a whole video on how redundancy works. And if you want to see that video, click the link up there. But with the disciplinary process, I do want to touch on the disciplinary process a little bit now. Having been involved in many disciplinary processes myself and been involved in the actual process behind managing that for various different companies I've worked for, I'm more than familiar with it and what you can and cannot get away with. Now, typically there are 3 types of disciplinary process at any one company. The terminologies might change, but they'll always generally fall into, well, they have to fall into these 3 categories, but the terminologies for them might slightly change, but in probably 75% of cases, they have these 3 terminologies. You've got the least severe, which is misconduct. Then you've got serious misconduct, and then gross misconduct. Now what happens is if a company finds you guilty of misconduct itself and they do fire you, then this is the one when people say, well, I went to a tribunal and ended up getting my job back or got a payoff. They generally got that because of misconduct. You see, misconduct can easily be construed as a genuine mistake. human error, lack of support, lack of training, all these different angles. And my recommendation, if you do ever get put into a disciplinary process, unless you've got a employment law degree, in which case you probably wouldn't be watching this video anyway, then you probably want legal advice or some support. Certainly if you want to keep your job and you don't want to get yourself fired and you want to get away with something. Certainly if you feel you're in the right anyway. But everyone's entitled to some form of defence. Why wouldn't you cover yourself? If you're a member of a union, then a union representative will come with you and they will be fully briefed and fully aware of what you need to do, or an employment lawyer can also help with this. Or if you have an independent colleague or something like that who volunteers to sit with you on the process to give you advice, some companies will allow for this, but bear in mind, many companies on their policy won't allow an internal employee to come in and help defend you, because it will be seen as a conflict of interest to the business. So you probably need to go externally from it. But if you do have a case where you are fired for just misconduct, those are the ones that can often be overturned because the severity of it is dubious. They can't do anything more than that. But if it ends up being serious misconduct or even gross misconduct, these ones, therefore, they found evidence of your guilt, that you have done something that you knew was wrong. You either signed a document, you've gone through training, there is a legal amount of paperwork that demonstrates you are competent to know that what you have done is wrong and you have done it anyway. And often this can be fraud, some sort of theft, you've committed a crime, you've done something which brings the company into disrepute. Any of those things, they come under serious or gross misconduct. And if I'm being honest with you, if you are fired for serious or gross misconduct, unless you've got some super lawyer to be able to get you out of it, chances are your appeal is going to fall on deaf ears. So bear those things in mind. The next one I want to go through is something called restrictive covenants. Now you might be familiar with the term non-compete, but basically a restrictive covenant is the same thing. And again, I could do a detailed video on that. If you want to see a video on restrictive covenants and non-compete clauses, do let me know and I will do it in more detail. So for this section, I'm just going to go through the brief parts of it. Now, restrictive covenant or a non-compete clause is something that's actually quite common in a lot of employment contracts without the employee actually knowing. And the employment contract itself would say something along the lines of, if you were to leave the company, you cannot go to a competitor, and you cannot, if you do go and work for a competitor, then take clients or contact existing clients that you have privileged knowledge about or sensitive knowledge about during your employment here for a set period of time, even after you have left the company. So for example, if you're doing a sales job or a management job and you have access to privileged client information and you go and work for a competitor, even if it's 2-3 months later, many employment contracts that have a non-compete or restrictive covenant clause within it will say to you, you cannot contact those clients. And although they are dubious into what will actually stand up, the key part here that will stand up in a court of law is if it can be proven by your old employer that you have used sensitive information and you have profited from the loss of your old employer by using that confidential information that you should not be using to your advantage, then they can sue you for damages. You can get a criminal record, you can be taken to court, but the other part, even if the criminal damages themselves, even the damage payments you pay aren't that much, the other problem is you could even be fired from your current employer for it. Certainly if you've been there less than 2 years when these restrictive covenants are going to last. Typically with any restrictive covenant, they can't last any longer than really a year. And if I'm being honest with you, unless you are in a management position or above, then the chances are you won't have enough clout for them to say that you could do the company serious damage, because you wouldn't have that level of seniority within their business. So restrictive covenants, to be honest with you, on many occasions aren't really worth the paper that they're printed on. But for certain things, certainly if you have been proven to take information and you have profited from it at your old employer's expense within the period that your restrictive covenant says you shouldn't, that's when they can take it to court and they can sue you for it. And the thing is, it's not even paying the damages that could be an issue, or even getting fired from your new employer that can be the issue. It's the court costs. Many employers will want to make an example of anyone that has taken a liberty when it comes to the restrictive covenant. What they'll do is go out and find an expensive lawyer who knows what they're doing, even despite the fact that they know they'll be able to get you banged to rights, and then you'll have to pick up that lawyer's fees if you lose the case. So bear in mind, if you are thinking about doing that, that can be something that you probably want to avoid, or you want to take legal advice to what you can or cannot do before you start doing that. And even if you think, oh, my employment contract doesn't contain a restrictive covenant, trust me, if you're in a management position or above, I'd certainly be picking that up, checking it out regardless. One thing with restrictive covenants though that I would point out that's pretty common that people don't realise would just be laughed out of a court of law is when they say you cannot work for a competitor in the industry. You see, they can't stop you legally working for a competitor as long as you are not going to that competitor and taking sensitive information with you to the competitor's advantage. If you're going to the competitor, you're not directly in competition with your old employer, you're not taking any sensitive information from them, you're not using it to your advantage, you're just going to work for a competitor, that's perfectly right. And you're protected by something called the 1998 Competitions Act. Competitions Act, in simple terms, basically means you cannot do your trade without working within your industry. So for example, if you're a plumber, a plumber's merchants then can't say to you, right, you can't go and work for another plumber's merchants because, you've got a restrictive covenant on your contract. How's that plumber then going to be able to pay their bills or have the income that they need to without using their trade? So it'll be thrown out of court, and that 1998 Competitions Act is there to protect you. So again, if an employer in your restrictive covenant says you cannot work for a competitor in the same industry, ignore that one. That will not stand up in a court of law. Now do bear in mind, I am not an employment lawyer. I'm not a certified expert, and I don't pretend to be giving you information that I can guarantee fact for fact. All of the information I'm giving you today is stuff that I know, but regardless, I would always advise anybody to take legal advice from a qualified professional if they do have a dispute or an issue with their employer and they could find themselves in hot water if they get it wrong. If you do have any questions on this, or you want to know more details, or you have any ideas for other videos, then do put them in the comments below. I do try to come back to every single person. It's getting difficult at times, depending on how well a video does, but I will come back to you, and I do tend to come back to you fairly quickly, to be honest. If you like this video, do consider giving us a like, do subscribe to the channel, click the bell icon and select all, and we'll see you for the next video.